This segment is sponsored by LawyerLisa. She is one of 5 certified elder attorneys in the state, and she joins us today to answer some important questions. We have Lisa Hostetler-Brown, or LawyerLisa, joining us with more. Thank you for being here.
Thank you so much for having me.
Yes, what you're going to talk about is so important for so many people watching. Let's just dive in, first of all. Why should you consider a trust instead of a will?
Yes, well, that's such a great question to start with, because a lot of people don't understand that a will means that your assets have to go through probate court when you pass away.
Okay.
And so a trust can completely avoid that. It just makes it an easier process on your family.
Right.
They don't have to worry about going into that process that takes usually about a year after you pass away.
That was my next question. So it's going to speed up the process versus a year is what you said is the average?
Yeah. And that's if everything goes the right way.
Right.
So if it doesn't go smoothly, it could take much longer than that. But if you have a trust, it goes smooth, fast, and your family can make distributions just the way you've said that you want it in your trust.
Okay, so no will, move it to a trust, number one. Number two, why you might want to consider medical planning in advance of an illness.
Yes, so the state of South Carolina has default objectives and plans for what happens in the event that you get sick, but those defaults might not be what you want. So maybe you do want your spouse making decisions, and if they're unavailable or you don't have a spouse, you do want your one child making a decision. But if you have more than one child, or you want a different family member doing stuff, you make those decisions yourself in advance with a healthcare power of attorney, living will, and HIPAA authorization.
And this can really destroy families sometimes, right? Like if they're left to try to figure it out and make decisions, so just having it all in writing and all done is going to make it easier.
Oh, you're so right. Yeah. There are so many family problems and so many situations that can happen if you don't have the right documents in place.
Okay, and speaking of documents, that brings me to the third question. The most important estate planning document, you say this is the financial durable power of attorney.
Yes, so this is my personal opinion, is that you do need a financial durable power of attorney, because while there are these default provisions written into the law for almost everything else, if you don't have a really good financial power of attorney and you get sick and your assets need to be moved around or protected, or your family needs to be able to get access to it, they're not going to be able to without having to go to court. And then they're in court trying to get a conservatorship, and a financial power of attorney that's really good can prevent that.
Now, excuse my ignorance, but a lot of times people just say power of attorney. Is that different when you say financial durable power of attorney?
It really is.
It really is. So it's a nuance that we need to address.
Yes. It's not a check the box document. So, well, you might check the box, I got a healthcare power of attorney. If you're getting a financial power of attorney, you need to make sure it has certain provisions. And so consulting with a really good elder law attorney can help you get the right documents.
Talk to LawyerLisa, and I hope you guys are taking notes at home and all this important stuff. Finally, if a family member is receiving skilled care or nursing care, like home level care, you should see if the assets can be restructured to maximize government benefits.
Yes.
What does all that mean?
This doesn't apply to everybody, of course, but for most people who maybe have, I'd say, less than $1 million in assets, it's a good idea to look into the options for preserving and protecting assets in the event that you need nursing home level care, which is running upwards of $10,000 a month right now. If you don't have a lot of money, you can run through that very quickly, especially if you're sick for several years. So there's some planning that can be done in advance through different types of trusts, and we generally call that Medicaid asset protection planning.
So at what age should people start this planning? When really should we sit down with you and have these conversations?
Yeah, so early planning, like setting up a trust to avoid probate, can happen early, 30s, 40s, 50s. When we're looking at whether or not you might need this asset protection, that's usually happening in the 60s and 70s.
Okay, and for someone watching right now, either if it's for them or a family member or someone they might know, what's the best way to get a hold of you and at least just start the conversation?
Oh yeah, well, we have a lot of information on our website. It's just LawyerLisa.com. So they can get a bunch more information for free. We have free classes that we put on, and if they want to do a consultation, all the information's on our website. It's just LawyerLisa.com.
There you go, LawyerLisa.com. So easy. Go to the website, and you said you have lots of free videos and documents to help out. Good to see you.
Thank you so much for
being here. And you know what? Thank you to all of our guests and our viewers at home. If you have any questions or comments, you can always go to our website, abcnews4.com. And if you want to be a guest, just like Lisa, you can fill out our Be a Guest form. The View is up next. We'll see you right back here tomorrow with more Low Country Live.